Well, I'm so pleased.
That's another subject. Why do folks vote against their own interests? I actually do have a lot of thoughts about that. Well, it's actually.
Hey, Randy. Good job. Thank you.
But it's a pleasure to meet you. How do you do? Just with
Yeah, I don't know that. I mean, I'm not a lawyer. I'm a historian. I really think
Oh, it's nice to yeah, it's hard to make. Certain things are hard to clear.
all about the difference between human equity and law.
Well, you know.
And it's all about that, and you can read about it, you just kind of pick it up. I'm sure there must be a book someplace, I don't know what it is.
Thank you. Well, I hope that was a little bit better.
Until I hit the wall, it was a monsoon. And we had a couple of days, the monsoon was gone, it's flooded good, and all of a sudden, there must have been, the accident must have been caused by the monsoon. Yeah.
Well, when 85 and 65, I've noticed you're traveling along, there's an accident.
Dr. Thornton, I enjoyed that very much. I didn't get a chance to speak. I enjoyed that. Is this something you've already written or you're working on?
I have already written it, but it's not published.
Okay, well, I hope you
I just
publish it.
finished it.
Great. Where do you think it? Okay, great. Because I'm glad because it makes clear what the article 100 years ago, whenever it was, that was in the I guess Alabama Lawyer, doesn't make clear. This you made it very clear, and I like that. So thank you.
This is what I was working on at.
Okay. Yeah. Okay. Well, great. I thoroughly enjoyed that. So it was wonderful. Where's Jeremy? Bum. He's reading a book, isn't he? I'm getting rid of all the books in the library just because of that. Whoops. Mike, I'm going to try. Let's see.
Little PowerPoint?
Yeah, oh yeah, very little PowerPoint. I can't get it. I don't know what the.
see where the technology got.
Yeah.
Go get him, Tom.
Kevin's coming. And he'll, I'll do my first, so there should be.
Okay, we're on our last panel for the day. And here to introduce our panelist is the Honorable Justice Tommy Bryan from the Alabama Supreme Court.
Good afternoon, everyone. I am Tommy Bryan. I serve as a justice on the Alabama Supreme Court. I've had the pleasure of serving as the people of Alabama since 2005, first on the Court of Civil Appeals, and then I was elected to the Supreme Court in 2012. I actually started in 2013. It's my pleasure to introduce the final two speakers of the afternoon. This has been an excellent symposium. The Blackstone and Burke Center for Law and Liberty always put on great symposiums. I'd like to thank Alan Mendenhall, Professor Michael DeBoer, and I'm sure many others for their hard work in pulling this together and asking me to be a small part of it. As to today's event has demonstrated, there's much to say about Alabama's Constitution, and that is not because of its length. But speaking of length, as I'm sure you are aware by now, Alabama's Constitution of 1901 has to date 946 amendments, which makes our Constitution 50 times longer than the United States Constitution. By way of comparison, the United States Constitution has been amended 27 times. That's in more than 2 centuries, but we have managed to amend 946 amendments in 120 years. For those attorneys practicing law in the state who feel somewhat intimidated by the Alabama Constitution, you can fear no more, for our next two speakers are going to break down various methods of interpreting our state constitution. First, we have Professor Michael DeBoer, Associate Law Professor at Jones School of Law here in Montgomery. Professor DeBoer is a constitutional scholar and has written extensively on rights given by and interpretive methods for state constitutions. For those of you that were here earlier today to hear retired Chief Justice Brett Dixon from the Indiana Supreme Court for his keynote address, you might find it interesting to know that Professor DeBoer got his first job out of law school with Chief Justice Dixon clerking for him for 2 years. Undoubtedly, that experience had a profound impact on Professor DeBoer, and it ignited his passion for state constitutional law. Professor DeBoer went on to teach constitutional law at Valparaiso University School of Law for 6 years, using the foundations that he built during his experience with the Chief Justice Dixon. Professor DeBoer will begin by introducing various approaches to state constitutional interpretation in broad context, and he will be followed by Tim Lewis, the director of the Supreme Court and State Law Library, who will speak about specific sources for attorneys and judges to use in interpreting Alabama's Constitution. Tim Lewis was appointed to his position by the Alabama Supreme Court in June 1992, although he served as assistant director of the library beginning in 1984. So, Tim, how old are you? You don't have to answer that. Tim has served as an adjunct professor at Jones School of Law, and he's currently an adjunct professor at Auburn University of Montgomery, where he teaches courses in Department of Justice and Public Safety. Tim has taught numerous courses on legal research and computer-assisted legal research, and he's the co-author of Alabama Practice Materials and Annotated Bibliography. Despite being the state law librarian, Tim is constantly chastising my staff for checking out real books from the state law library because he says books are obsolete. Having worked with Tim for many years, I can tell you that there is no one better to liven up a discussion about state constitutional interpretation. Although I did speak to him shortly after I arrived here today, and I haven't seen him this nervous since we had a going-away party for someone of his staff in the unusually off-limit rare books portion of the state law library. He was constantly monitoring our punch intake and our cookies and wouldn't let us have candles in that section of the library. But I think he'll be okay. Please welcome Professor Michael DeBoer and Tim Lewis.
Were you going to switch this over? For Tim's presentation, he's going to use a PowerPoint, so we just want to switch that over here quickly if we can.
It's not this one?
It is that one.
Okay.
Yes. Okay.
Yeah.
So Tim is ready to go. All right. Well, thank you, Justice Bryan, for introducing the panel here and for turning our attention to the focus of this session, which is state constitutional interpretation. And if you're still here in the room with me, you are the diehards. For two reasons. One, it's the last session of the day. And then second, because of the topic. So state constitutional interpretation is something that may not get everybody excited, but I'm happy to be here to talk about it today. You know, in a sense, all of today's presentations play a part in helping us to become better interpreters of the Alabama Constitution. For the more we learn about the texts and their histories, the better we are able to understand and interpret the Constitution. Nevertheless, this session will focus on methods of interpretation and the sources to help us interpret. My remarks this afternoon will develop in 3 steps. First, I will discuss 5 periods of state constitution making. Second, I will address in additional detail the current period of state constitution making, which some have labeled the new judicial federalism. And third, I will discuss approaches to state constitutional interpretation and come back to the Alabama Constitution. So first, talking about the periods of state constitution making. From my study of state constitutions and state constitutional law, I have concluded that 5 broad periods of state constitution making may be identified in our nation's history. The first period of state constitution making runs from 1776 to 1791, so a relatively short period. During this period, 14 states entered the Union, and most of these states adopted their first constitutions and bills of rights. In the new nation, these state constitutions and bills of rights provided for the particular frame of government that were used within these states, the particular frame of government, and protected citizens against government interference by spelling out in writing the rights of the people. The state constitutions and Bill of Rights adopted during this first period of state constitution making established patterns and set forth verbal formulations that the framers of other state constitutions and Bills of Rights borrowed from and adapted as the nation expanded westward. The literature out there uses the word plagiarism to talk about what states did with other state constitutions as they adopted the work of other states. It is also noteworthy that many of these state constitutions and Bills of Rights were adopted before the United States Constitution was approved for ratification in 1787 and before the Federal Bill of Rights was ratified in 1791. The second period of state constitution making runs from 1792 to the early 1830s. During this period, a second wave of 10 states entered the Union, including our state, Alabama. As these states joined the United States, they adopted their own constitutions, Bills of Rights, drawing upon the earlier adopted constitutions and adapting the patterns and the verbal formulations that were found therein. Alabama adopted its first constitution during the second period of state constitution making, when on July 30, 1819, the delegates to the Constitutional Convention in Huntsville approved the state's first constitution. It was then signed officially on August 2nd. This constitution began with a preamble, and Article 1 was a Declaration of Rights. This article was followed by 5 additional articles. Article 6, which set forth general provisions, included 3 sections on slavery, or slaves, that restricted the authority of the General Assembly and provided minimal protections for enslaved people. Alabama was then granted statehood on December 14, 1819. So that was the second period of state constitution making. The third period of state constitution making extends from the mid-1830s to the 1920s. During this period, 24 more states joined the United States and adopted their own constitutions and Bills of Rights, again, often drawing upon the existing patterns in the verbal formulations in other state constitutions. Also during this period, some states adopted new constitutions that differed from the constitutions that they had adopted earlier. For instance, Indiana adopted a second state constitution in 1851 that replaced the constitution that it had adopted in 1816 when it became a state. The Civil War also factored significantly into the state constitution making during this period, and this is well illustrated in Alabama's constitutional history. So in 1861, Alabama adopted its second constitution as part of its departure from the Union, and in 1865, it adopted its third constitution in re-entering the Union after the war. In response to additional federal requirements, Alabama adopted a fourth constitution in 1868, and then Alabama adopted its fifth state constitution in 1875 after Democrats regained power in the state legislature. And then, as we've talked about, in 1901, Alabama adopted its sixth state constitution, which remains the current governing state constitution. But this lengthy constitution has been amended hundreds of times, as we've talked about. And thus we see that 5 of the 6 Alabama state constitutions were adopted during this third period of state constitution making. So it's an important period, at least for our state, and the state constitution. The fourth period of state constitution making runs from the 1920s to the 1970s, the mid-1970s. During this period, 2 new states joined the United States. You could probably guess what they were. A little civic education here. There you go. However, what is significant about state constitution making during this period is the federal constitutional overshadowing of the state constitutions that became primary in this period. This overshadowing stemmed in significant part from the United States Supreme Court's development of the incorporation doctrine. Originally, the Federal Bill of Rights applied only to the federal government. However, in the 20th century, the court made select provisions of the Federal Bill of Rights applicable to the states through the Due Process Clause of the 14th Amendment. Over time, most, but not all, of the rights recognized in the Federal Bill of Rights were incorporated and made applicable to the states. And once the incorporation doctrine was coupled with an activist judicial philosophy in the middle of the 20th century, federal constitutionalism moved to the center of the American constitutional stage, and state constitutionalism moved to the perimeter. Responding to this federal constitutional dominance, some state Supreme Courts adopted what Justice Dixon referred to earlier as a lockstep interpretive approach to state constitutional provisions. Accordingly, rather than independently analyzing the state constitutional provisions, these courts that adopted the lockstep approach embraced the Supreme Court's interpretations of the federal Constitution when they interpreted counterpart provisions of the state constitutions. The fifth period of state constitution making extends from the late 1970s to the present time. During this period, state constitutional protections began to receive renewed attention as a new movement called the New Judicial Federalism emerged in the late 1970s. This movement has been understood to be a response to the apparent reluctance of the Burger Court and the Rehnquist Court to give expansive recognition to federal constitutional rights. And it received early encouragement from Justice William Brennan, who served on the Warren Court, the Burger Court, and the Rehnquist Court, and called upon state courts to rediscover their state constitutions. This movement has inspired some state judges to refocus on state constitutions to secure rights that are not protected under the United States Constitution. As a consequence of this movement, state constitutional law has reclaimed its standing as an essential component of American constitutionalism. So those are the 5 periods of state constitution making that I've identified. Now, a little bit more about this new judicial federalism movement. As I said, in 1977, Justice Brennan observed that the tide of the United States Supreme Court activism had begun to turn, and that proponents of individual rights needed to shift their attention to state constitutions and the rights protected therein. He urged state courts and litigants to extend the rights protection effort beyond the United States Constitution to the state constitutions, which he viewed as fonts of individual liberties with protections that often reach beyond those required by the Supreme Court's interpretation of the federal Constitution. In the 4 decades since Justice Brennan issued this call, the renewed focus on rights protections in state constitutions developed into a movement, with many state courts giving careful attention to their respective state constitutions and the double protection afforded by the federal and state bills of rights. And Justice Dixon was here to talk about Indiana's experience in this movement. Although I have to probably clarify that comment. He would not see his effort as being part of some sort of movement or some sort of activism. I think if he were to speak to that specific question, he would say something more along the lines of, this is just part of the return to one of the foundational documents that governs in our country. This has raised the stakes, this movement of new judicial federalism, this has raised the stakes for state courts as they endeavor to address new constitutional claims, as they seek to study the text and the history of their respective state constitutions and interpret their state constitutional provisions. The renewed focus on the state constitutions has not been limited, though, to state bills of rights. State courts have also looked to other articles like the separation of powers article, the separation of powers article, the legislative article, the education article, state institution articles, and interpreted provisions contained with those different articles. It is important to note here that state courts who are asked to interpret state constitutional provisions face a unique interpretive challenge in our federal system, especially when federal and state constitutional issues are presented together in a case. This interpretive challenge involves the reconciliation of federal constitutional interpretations with state constitutional interpretations, and several approaches have developed among interpreters of state constitutions. Justice Dixon, in his remarks, referred to 2 of these. I'm going to talk about 5. According to one approach, the primacy approach, state Supreme Courts should examine and resolve the state constitutional issues first, before turning to the federal constitutional interpretations. This approach is premised upon an understanding that the states are the primary sovereigns in our republic, and that state constitutions are fundamental laws that have independent status and are separate sources of rights. Under a second approach, the supplemental approach, state Supreme Courts first address the federal constitutional issue and then the state constitutional issue to see if the state constitution provides any right or protection supplemental to or that help to amplify the federal constitutional right or protection. Under a third approach, the dual sovereignty approach, state Supreme Courts evaluate and rule on both the federal constitutional issue and the state constitutional issue, reaching independent decisions on both. A fourth approach, which we've already mentioned here, the lockstep or absolute harmony approach, is an interpretive approach in which state Supreme Courts defer to the United States Supreme Court's interpretations of parallel provisions of the federal Constitution and conform their interpretations of state constitutional provisions to federal constitutional jurisprudence. Under a fifth interpretive approach, the criteria or factors approach, state courts consider various criteria or factors, such as constitutional texts, constitutional and other relevant history, precedent, in interpreting their state provisions and determining when to treat a state constitutional provision as an independent source of rights. So having discussed the new judicial federalism as a movement and a unique challenge facing interpreters of state constitutions in our federal constitutional order, let me turn now to several approaches to interpreting state constitutions. In the 20th century, approaches to the interpretation of texts have proliferated. We know this in literature, we know this in theology, we know this in law, that interpretations of texts have undergone a lot of reconsideration. Different approaches are taken. Some focus on the author, some focus on the text, some focus on the reader, and there are other interpretive approaches that can be found. An interpreter's approach plays a decisive role in the interpreter's engagement with a text and determines whether focus is placed on the author's intention, the historical context of the author, or whether focus is placed on the grammar and the syntax of a text, the dictionary definitions of terms, or the original understanding of the author and the audience, or even whether focus is placed on the sense a reader makes of a particular text or document or terms, the values inherent therein, the principles therein, and the meaning that the reader produces as to a text. Differences among interpretive approaches have translated into different theories of constitutional interpretation. Some constitutional interpreters focus on the text and the words of a constitutional provision, while others focus on the intent of the framers and constitutional design. Still others move beyond the text and the words to determine underlying values and give to principles new applications in a current context. Different approaches, too, are evident in Alabama Supreme Court decisions. Because of the limits of time here, I'll focus here on 3 approaches exhibited in Alabama Supreme Court decisions. First, I was able to find the lockstep approach exhibited in an Alabama Supreme Court case. For instance, in Elliott versus Van Cleef, the court stated, "This court has interpreted the due process guarantee under the Alabama Constitution to be coextensive with the due process guarantee under the United States Constitution." Now, due process is mentioned 2 times in the Alabama Bill of Rights, and the language in both of those provisions is very different than the due process clause found in the 5th Amendment and the 14th Amendment to the United States Constitution. In support of this proposition, so this is from Elliott Van Cleef. The court cited 2 Alabama Supreme Court precedents that were decided during the 4th period of state constitution making. In other words, that period during which federal dominance characterized state constitution making. It was also during the 4th period of state constitution making that the Alabama Supreme Court stated that sections 1, 6, and 22 of the Alabama Constitution combine to guarantee equal protection of laws. Although the court later correctly observed that the Alabama Constitution does not include an equal protection clause and sought to provide an explanation for the court's earlier error, the court decision in 1977 serves to illustrate how federal overshadowing may play a role even here in our state's constitutional interpretation. Second, near the beginning of the 4th period of state constitution making, the Alabama Supreme Court recognized that the United States Supreme Court interpretations of counterpart provisions play a persuasive role in state constitutional interpretation. In Pickett versus Matthews, the court stated that when the court construes similar features of the state constitutions as applicable to the same situation to which the United States Supreme Court applied the United States Constitution, the decisions of the United States Supreme Court, though not controlling on us, should be persuasive. And then third, another approach to state constitutional interpretation is exhibited in Ex parte, I think you say Meloff, M-E-L-O-F, in which Justice Houston determined that the Alabama Constitution has no equal protection clause, and thus corrected an error that had been made in several opinions of the Supreme Court. The court in Ex parte Meloff reiterated what the court had earlier determined in its 1949 opinion of the justices number 102. In addressing the question regarding the quote-unquote phantom equal protection provision of the Alabama Constitution of 1901, the court sought to understand what led the court's 1977 decision that the 1901 Constitution included an equal protection provision, and it looked to several sources to try to unpack what may have happened here. And I note some of the sources that the court looked to in resolving this. One, the official proceedings of the Constitutional Convention of 1901, the discussion of convention delegates at that 1901 convention, convention committee proceedings, relevant provisions of the 1875 Constitution, relevant provisions of the 1868 Constitution, court precedents, and the court looked to an inaccurate, unofficial annotation in the Alabama Code. Although Justice Houston wrote the majority opinion for the court, he also filed a special concurrence in which he expressly referenced a concern about judicial restraint in offering a more extended defense of the court's ruling. In his special concurrence, he highlighted the quote-unquote unavoidable truth, and here the quote continues, that the power to amend the Constitution rests with the people of the state of Alabama, not with members of the court. And he urged that, and I'm quoting again, as a legal document, a Constitution can change only if the parties who gave effect to the document, the people, call for a change. The quote continues, this recognition of the exclusive right of the people to change their own Constitution is inherent in the amendment procedure. Although the Alabama Supreme Court has exhibited different approaches to state constitutional interpretation, it appears that the court has embraced a judicial philosophy of restraint, a philosophy that honors the constitutional text and its history and seeks to grasp the meaning of the text as it was commonly understood at the time of adoption by the people. Attorney Mark Ayers, who served Justice Houston on the court, has observed that, by all accounts, Alabama courts are in the Constitution as a legal document camp and not in the Constitution as a living document camp. This judicial philosophy of restraint, he explains, leaves it to the people to judge when a social change is a good change that should receive constitutional recognition. And now, by way of conclusion, Alabama lawyers and judges play a key role in interpreting the Alabama Constitution. and the approach to interpretation that they take is an important matter. Their role and their interpretive approach cannot be the importance of their role and the interpretive approach cannot be understated. However, it must also be remembered that it is we, the people of Alabama, who retain the most fundamental power as far as our government is concerned, and that is the power to change our Constitution and even to change our form of government. For all political power, the Constitution says, is inherent in the people, and all free governments are founded on their authority and instituted for their benefit. To the extent that Alabama courts observe a judicial philosophy of restraint when they interpret the Alabama Constitution, they help to safeguard the power of the people, even now in this fifth period of state constitution making.
Well, y'all are really, really troopers to still be here, let me tell you. My name is Tim Lewis, and I appreciate Alan inviting me to talk about sources for interpreting the Alabama Constitution of 1901, and I appreciate Justice Bryan's introduction. Thank you, sir. If we lit candles in the rare book room, we would set the halon off. So and also, I'm afraid one of his staff is trying to steal our first edition of Blackstone's commentaries, so I keep a good eye on him all the time. So. Anyway, what I'm going to talk about tonight is the sources for interpreting the Alabama Constitution. I was sitting there thinking, this should be something I do on Halloween after 4 o'clock, since a librarian with a PowerPoint is one of the most frightening things you'll ever see. But, it's only 8 slides, so we can get through this pretty quick. So what we're going to talk about basically, let's see if I can make this up. That's not what I need. All right, went too far. This is a pointer. I thought it was something different. Now if I can just get back. All right. Basically, I'm going to talk about the document itself, which is, you got to have access to the document itself to interpret it. The official proceedings of the Constitutional Convention of 1901 are a verbatim transcript of everything everybody said and committee reports and everything. It is incredible what was said, and they took it down. And there was a big debate whether they were even going to do this. And fortunately, the ones who wanted to transcribe it won. So we have access to the intent, the way of interpreting it right there. And plus, I'm going to talk just a little bit about the main interpreter of the Constitution, which is the courts. And some interesting things I found out about that. But let me talk about the Constitution of 1901. The first 2 volumes of the Code of Alabama contain the Constitution of 1901. Generally, that's been the case. The Constitution was always in the first few volumes. But if you look at the volume 1 of the Code, you see it's the official recompilation of the Constitution of 1901 as amended. And what that means is in 2003, the legislature gave the Code Commissioner the power to do what should have been done at the very beginning, which is take the amendments and put them in the body of the Constitution, okay, and separate out the local amendments into a separate volume. So you've got volume 1, which is the Constitution of 1901 as amended by amendments of general application for the whole state. And in volume 2, you've got the local amendments set out by county, and of course they're still doing that, and they're not through with that. So that way you can separate it out and your research can be better. So this is a recompilation. And for some reason I believe that they, I don't have any real reason to believe this, but they didn't really put the amendments in the body because I think they wanted it to be long. They wanted it to be long. They wanted a new constitution. A lot of people did. What better way than have this huge, giant document? When I first started working as a librarian, every week we'd get copies. Please send me a copy of the Constitution of 1901. Well, I'd say, well, if you give me 2 weeks and about $50, $60, we can copy the whole thing for you, but it's going to take a while. So it should get shorter this way, but it's still going to be a long document. One of the great values of the access to the code. The hard copy is the annotations. The annotations are court cases that have interpreted the Constitution, things like that, things like amendments. And this is found in the hard copy. Okay, of course, everybody but one person on Justice Bryan's staff wants to use digital stuff, but, so Allison, which is the website of the Alabama legislature, and I've given you the URL there, is where the Constitution of 1901 is found more or less officially because it's the legislature's site. All the 946 amendments are listed there, but it is unannotated. Okay, it doesn't have the annotations that the Code of Alabama has in hard copy, which is critical if you want to see cases interpreting the Constitution. Other sources, Westlaw and Lexis, got to subscribe to those, so you better have some kind of access. They both have the Constitution annotated. One thing you got to remember, annotations in Westlaw are different than annotations in Lexis, because Westlaw, West publishes the Alabama Code. The annotations to the Alabama Code belong to the state, so when they change publishers, they change annotations. So as a lawyer, if you're looking at the Lexis Code and the Westlaw Code, or say you're looking at using the Lexis Code, you're not looking at the same annotations that the judge is looking at because they get the West Code of Alabama. I don't know how much difference that makes. It's just something to remember. The same would be true of the Constitution. Okay. Great source for the Constitution of every state is something called Hein Online. Hein Online is a subscription service, but it's a heck of a lot cheaper than Westlaw or Lexis. And I will talk to you about a search I did on the Constitution of 1901 on Hein Online in a few minutes. There are several free sources to the Constitution of Alabama, 1901 Constitution. These are some of them. I was surprised that something called Ballotpedia has it, but they do. Again, these don't include any annotations. They're just the straight text of the document, which is great to have it digitally, but you're not getting any of the interpretation. Okay. All right. Talking about primary sources here, when the Constitution was adopted, newspapers, that's where it was pretty much, I guess, before it was really adopted so people could see it before they voted on it. The Constitution was put in newspapers. You can look at Montgomery Advertisers. They have the full text of the Constitution. Of course, it hadn't got the 946 amendments, so it's not that long. But that's one way that people first saw it. It first appeared in a official state publication, as far as I know, in the Code of Alabama of 1907. For some reason, they placed it in Volume 3 of the Criminal Code. And one of the interesting things about this is it's put in the format of a side-by-side comparison with the Constitution of 1875, which I've read from a lot of scholars that they were not that different from each other. The Code Commissioner at the time was J.J. Mayfield. James Jefferson Mayfield had been a Supreme Court Justice and was a trial judge. And you will see his name from 1907 to 1923 involved with the publication of the Code, including the Constitution. He also published a separate book which included the 1875 and 1901 Constitution in parallel form again, annotated and indexed, which is pretty critical, when I'll get to in a few minutes. It was published in 1918, so again, it wasn't overladen with amendments. Again, Mayfield, as I said, was the author. In 1923, he again was the Code Commissioner. Did the same thing with the 1875 and the 1902 Constitution, side by side, paralleled in Volume 1, the Political Code. So Mayfield had a huge impact in the way the Constitution and the Code was published. As a matter of fact, 1923 codes are really two of the best organized, well-done codes that we have, and that's thanks to Mayfield. In codes after Mayfield's time, in the 1940 Code and the 58 recompiled in the Code of 1975, again, the Constitution of 1901 appears in the first two volumes now. And in previous codes, and I think they still do include all the constitutions of Alabama, not in the parallel format. But again, with any of the codes, you get the annotations, which is the interpretations by the courts. Okay. I talked about the official proceedings of the Constitutional Convention. It's really incredible that we have this 4-volume work originally published right after the convention and reprinted in 40. It is a verbatim account of the session in a newspaper type form. It includes everything, reports, documents, petitions, and debates, but it had no index. It had no index at all. Don't know if that was intentional. I have no idea. There was no index until 40 years later. The official proceedings index was actually commissioned by the Supreme Court. They, of course, what were they doing? They were using the proceedings to interpret the Constitution. It had no index. So they commissioned West Publishing Company to come up with an index, which they did. I'm sure they paid them well. It's about 245 pages long. For some reason, in 1948, the court commissioned another index. This one was 85 pages long. Haven't really studied the two, but I would use the 42 version, I think, because it's going to have more to it. But for 41 years, there was no index to the official proceedings. So you wanted to dig out any interpretation or intent, you had to read the whole thing practically. But that was solved. Now, the index to the official proceedings is also on the legislature's website. No, it's not. It's on Archives' website. They have digitized that, so it is on Archives and History's website. Okay, I'm going to run through some secondary sources, and I apologize in advance if there's somebody here who's written a secondary source about the Constitution of 1901 and I've missed it. But there's several. The Alabama Constitution Annotated is one of my favorite, although way out of date books. It is a complete digest of all the decisions of the Supreme Court of Alabama construing the Constitution of 1901 as amended. The author was a Birmingham lawyer named Thomas E. Skinner, but unfortunately it was published in 1938. So we've got, 80, almost an 80 years of nothing there, but it is a good concept. I wish someone would pick it up and redo it. It includes provisions of all the constitutions, 1819, 1861, 65, 68, and 75. It is currently out of print. I don't think you can find one anywhere, but that was a neat concept in 1938. I keep one in my office. It's just really was Mr. Skinner did a great job. In 78, there's the Constitutional Development in Alabama by Malcolm McMillan. Excellent book, a lot of background. I'm not sure useful as interpretation, but it's an excellent book. Dr. William H. Stewart published in 1994 the Alabama State Constitutional Reference Guide. He did that he did a second edition in 2011, very handy book. In 1997, there was the second edition of Alabama Constitutional Law by the late Albert Brewer and Professor Cole. It is a case book, but nonetheless, it is a valuable book. Unfortunately, it too is being dated. The last one, A Century of Controversy by Bailey Thompson, 2019 or 18 or 2019, it's not. I mean, it's a good background of the Constitution and the road to the Constitution, but it may or may not be that useful for interpretation in a legal sense. All right, there's only 7 slides. Okay, I said I would mention the courts because the courts interpret the Constitution. In 2012, I had a volunteer take the table of cases from the Alabama Digest to see if we could figure out how many cases had been published in the reports, the Alabama reports, the Alabama Reporter. He came up with over 120,000 published cases, many of these being memorandum decisions, by a lot of the Court of Appeals and the Court of Criminal Appeals. I did a Westlaw search using just, the Constitution of 1901 in various and sundry shapes, and found that the Alabama appellate courts, it's been mentioned in 3,465 published cases. I think that's low. I need to redo that search. In doing a Westlaw search of the federal court databases, I found 630 published cases. Again, I think that's low. And I was doing a very general search there, so it wasn't like it was overly complicated. So I'm going to redo those searches because I do think those are low. I think when we're talking about well over 120,000 published cases by the Alabama appellate courts, 3,500 doesn't sound, interpreting the Constitution doesn't sound like a lot, but I could be wrong. And I mentioned Hine Online. I did a search on Hine Online citing sources citing the Constitution of 1901, and Hine Online is everything from journals, legal journals, all the way back to Volume 1, Harvard Law Journal, things like that. It's bar journals. It includes some case law databases, and I've got 42,707 articles and cases from Hine Online. Again, I didn't explore that too deeply, but we'll go back and look at that. And that is the quick and dirty overview of sources of the interpreting the Constitution of 1901. Again, it is the courts that interpret the Constitution, but when you've got something as just as, I don't even know how to describe the official proceedings. I mean, they just say it, and it's not difficult to interpret some of the things they said. So when you've got that, then of course the document yourself, these are the main sources for interpreting the Constitution. So, any questions, anything like that? Yes.
In view of how many amendments there have been over the 100+ years since the Constitution of 1901, and in view of the fact that the historical context, at least the best evidence tells us that the proceedings are infused with racism. In trying to understand the provisions of the Constitution, at least those that were adopted in 1901, is it, as opposed to those that were already there, is there any real value in going to the official proceedings? Because they're really just doing it on account of race. That's not really going to legitimize any kind of interpretation of the new provisions.
I see your point. But I don't think I mean, there is about racism, but I think there's other things too. So there, it's not just, there's more than racism involved. Yeah.
In a sense, it's a small segment of the document.
The racism part.
No, I'm talking about what was adopted.
What was adopted for this? Yeah.
Partly because it has so much later that's not adopted.
Right. You're right. I mean, most of the amendments came later. Well, I'm not going to say yes or no, but for years we provided a set of those in every judge's chamber, and they commissioned the index. So I feel like, in 1942, the court felt like that was important in interpreting the Constitution, else they would not have gone to the effort of having an index just to the proceedings, because it is an index of the proceedings, not of the document itself.
I would say a few things. Looking at the phantom equal protection clause that I referenced there, and looking at what Justice Houston did, he went back to those official proceedings to try to understand how was this provision or these provisions that were at issue, how were they understood at that time, and setting those in context. And I mean, I haven't looked at that specific question, but I'm guessing that the historical materials related to those provisions wouldn't be marked by the same sort of racism that you would find as to other parts of the Constitution.
The ones that predate 1901.
Well, even the things that are tainted by that in the 1901 Constitution, kind of doing the work of a historian, trying to understand each of these provisions to an extent are set in a historical context. And so you're trying to understand those provisions. Some of them, like for instance, I referenced the provision regarding all political powers inherent in the people. That provision is found across these 6 state constitutions. And trying to understand the scope of that provision and what it means, I don't think it would take you into all the materials regarding racism and so forth. And so, doing the work of the historian, that's what you would be trying to do. And of course, each of those amendments now have their own historical context as well. And so I think that's what I'm trying to say is we're trying to do some work here, not only as interpreters of texts, but also trying to understand their historical setting. But you're right that context in which the convention took place, I think causes you to be a very careful reader.
There's so much there now in view of the problems associated with that convention. It makes you wonder why we insist on continuing to call it the Constitution of 1901. Why do we use that label?
Yeah, well.
In a sense, the document has become something entirely different from 1901.
Yeah, although, you can think of it as a frame, or you can think of it as a skeleton. I mean, that's still the frame or the skeleton on which we're hanging these different amendments. So there is a framework set by that.
The skeleton precedes 1901.
In what sense are you saying that?
The whole bulk of the government does. The structure of the departments, the delegation of power to local governments, although there's some that's appropriated to the central government in 01, but it's appropriated earlier than 01 as well.
Right, but I guess the question that I would have is, as we're trying to understand that government now and the authority of a specific branch or department, as we're trying to understand that, is the relevant text the 1901 text or the 1861 text or one of these other texts? And even though there's a history there that I think needs to be understood, as far as what is the governing text now, I still think it's the 1901.
What I'm saying is most of the race-neutral texts tend to precede the 01 Constitution. And so they should, first of all, they shouldn't suffer the taint unless you can prove that they were retained for some racial purpose.
Yes, and what's remarkable about those texts, too, that are not racially tainted is they have a history in the Kentucky Constitution and Pennsylvania's Constitution and so forth. So as we're doing the work of trying to understand the text, it actually takes us to the text in other state constitutions as well. And I think that's the work of a historian, to try to understand the text in context. Did we somewhat answer? Well, I mean, this is as somebody from another state who's moved here, who's been here almost a decade now, this is an interesting thing because I hear very few people defending our state constitution in terms of, this is something that, we're really proud of. Everybody kind of recognizes some of the problems that are part of this text. Nobody seems to not acknowledge that, but
when I cite it in a brief, I don't even cite the year because it's just the most current provision, and you just take the text as it is. Unless you want to introduce some other ideas, we don't need to tell you what year it was. Plus, I need to stay.
Well, in fairness, it is called the recompiled Constitution of 1901.
Well,
so.
Right. What are they? They're recompiling based upon.
Yeah. But, changes, yeah. So, in fairness, it is. Okay, if no one else, thank y'all very much.
Let me just wrap up here quickly. So this brings us to the end of our time. we do have some additional time up in the exhibit hall. If some of you are interested in returning to that space and seeing the materials up there, maybe you haven't had an opportunity to give that the time that you would like, that room is still available up on the second floor, and you're welcome to go there. We have set aside for that 4:30 to 5 o'clock. So you're welcome to do that. But otherwise, we are finished here. Thank you for coming and being a part of this.
Thank you. If I can just... Thank you, Mike. Appreciate that. Thank you, Chief. I appreciate it.
Hey, would you send me that PowerPoint?
Yeah, sure.
I didn't get it.
Well, I should have made copies. And
No, that's all right.
Now I got to figure out how to get my flash drive. Here it is, right there. That was a good question he had. Really was. It may be that the courts now don't attach as much value to the proceedings, but at one time they certainly did. Of course, that's been some time ago. So, a good point. I mean, but I just maybe it's just the fascination of the of reading the thing.
What's interesting to me, and this is where the federal people today read some of this and they don't know what that language would have meant essentially. And we think, oh, we already know what that means. Thank you for being a part of this.